My Lord, I'm going to move to Lord Will's amendments. Amendments 125, 126 and 147 stand in his name, and they look much more broadly at the issues of whistleblowing and seek to change some of the most egregiously inadequate features of the existing Public Interest Disclosure Act. I've added my name. The last government initiated a review of the whistleblowing framework covering many of these issues, but it has never been published. And I ask the Minister, will she publish now? Now, PIDA, that's the short form, sits within employment law. It identifies certain prescribed people to whom a whistleblower can confidentially disclose information. But when a whistleblower is exposed, as often happens, it uses the Employment Tribunal as its mechanism to protect whistleblowers. That protection is available only for whistleblowers who are also workers. Amendment 126 seeks to expand the definition of a worker to include self-employed contractors, sub-postmasters, the judiciary, non-execs, trustees, trade union reps and job applicants. I suspect that most people in this House have been unaware of how many people are not covered by the current whistleblowing framework. Now, this improvement can only stretch the definition so far because PIDA is in employment law, so clients, suppliers, relatives, associates, I could go on, will still not be covered, but some improvement is better than none. When a whistleblower is covered by PIDA and becomes a victim of retaliation because of their whistleblowing, they can take a case to the Employment Tribunal. However, in tribunal, the whistleblower must prove to a very high standard that they received detriment because of their whistleblowing. That is why 96% of whistleblowers acknowledged by the tribunal as whistleblowers still lose their cases or are forced to settle and sign an NDA. To win, they have to produce evidence such as an email trail, usually wiped clean, or a manager involved in their dismissal who will testify definitively. Now, Amendment 125 reverses that burden of proof and says if you are a whistleblower, it should be assumed by the tribunal that you have been fired because of your whistleblowing unless the employer can demonstrate otherwise. And lastly, on Lord Wills's group of amendments, let me address 147, which requires an employer to take reasonable steps to investigate information disclosed by a whistleblower. This follows on from Baroness Morrissey's amendment in an earlier group. There are some brilliant companies and agencies that will leap on a piece of information and check it out seriously. Usually, however, the wagons are circled to protect a reputation, sometimes profits. Every survey of whistleblowers shows that their number one concern, even above their own well-being, is investigation.